we have the great pleasure to welcome you on behalf of the Digital Law Center, as well as on behalf of the WIPO Arbitration and Mediation Center, with which we are very pleased and honored to co-host this event. I will not make a long introduction because we have a great program and a great line-up of speakers today with a slight change to which I will turn in a few seconds. The program today is as follows. So we will start by a presentation that shall be made by our esteemed colleagues from the WIPO Arbitration and Mediation Center. That is Ignacio de Castro, who is the Director of the IP Dispute and External Relations at the WIPO Arbitration and Mediation Center, as well as by Margarita Kato, who is Legal Case Manager at the WIPO Arbitration Mediation Center. And they will start by presenting the recent activities and projects of the center about data disputes. And I will give them the virtual floor in a few seconds. And then we will turn to Alejandro Garcia, who is a highly experienced arbitration practitioner with the law firm Clyde Co, who is based in London. And among his many achievements, he is the co-author of a leading book on IP arbitration, and he's also a member of the recently created advisory committee of the WIPO Arbitration and Mediation Center. And Alejandro Garcia will speak about data disputes in international investment law and investment arbitration. And as for our last speaker, we're supposed to welcome virtually Mary Walker, who is a very experienced barrister, arbitrator, and mediator based in Sydney, Australia, who unfortunately is not in a position to join us today for health reasons. Mary Walker was supposed to present and discuss a recent Australian regulation providing for mediation and arbitration with respect to a certain type of data and revenue sharing dispute in the digital context. Given that Mary Walker cannot be with us, I will share a few thoughts about this topic, of course, from the perspective of an outside observer. And then we will open up the floor for discussion and interaction with all of you, with the audience. And we will do so by offering you the opportunity to raise your hand or to put questions in writing in the chat function of this Zoom session. Please do feel free to share your thoughts, comments, and questions with our distinguished panelists, and we plan to address them at the end of the session. Please note also that the session is recorded, as you should see on the screen. And without further ado, let me now give the virtual floor to our first speakers, Margarita Kato and Ignacio de Castro from the WIPO Arbitration and Mediation Center.
Thank you, Jacques. I'll just share my screen and hopefully you'll be able to see our slides.
Oui.
So I'm hoping everyone can see that. So thank you everyone for joining us. So I will
hear you, I think, Rita.
Sorry? Okay, so thank you again all for joining us. So I'll be speaking today on the WIPO, some of the activities of the WIPO Center, and then Ignacio de Castro will follow on from that to discuss a few other aspects of our services. So just to provide some general background on the WIPO Arbitration and Mediation Center, we are part of the World Intellectual Property Organization, which is a UN agency, and whose role it is to promote innovation and creativity through a effective international IP system. And in that context, the WIPO Center is an ADR provider, and we facilitate the resolution of commercial disputes between private parties through out-of-court procedures. And some of our sort of key features are that we are internationally neutral by virtue of being part of the UN. Whilst we deal with disputes from all sectors, we specialize in IP and technology disputes. We also have offices in Geneva and in Singapore, and we have users from around the world. So our role in managing disputes is to provide information and procedural advice on ADR options. So often if parties don't know which ADR option they would like to utilize in dispute, for instance, mediation or arbitration, or they're perhaps unfamiliar with what those options entail, we can provide advice and provide procedural guidance on what each of those options will entail. We also provide recommended clauses and submission agreements. Some of the time, these are tailored to specific sectors, and I will cover that a little bit later. So the recommended clauses and submissions are for the different ADR options we provide, and that includes mediation, arbitration, and then expedited arbitration and expert determination. And the other role that we have is to also assist parties in selecting their neutrals. So we help them to select specialized mediators or arbitrators or experts. So often parties may already have in mind who they would like to assist in dispute, but if they don't, we have an extensive list of neutrals from which parties can select a neutral, and we advise with who they may be able to select. And we also provide other logistical support, including providing meeting rooms and virtual video conferencing facilities. So I just wanted to provide some general information on our caseload and just draw your attention to the legal areas in which we're active and also the location of various parties to our cases. So as you can see, we have very diverse parties from a number of different countries and different areas, and 69% of our cases are international, meaning that both parties are from different countries. Our settlement rate is also something we're very happy with. For instance, in 2020, we had a 78% settlement rate in WIPO mediation, and that has been increasing year on year, which is also really great to see. So that's just some general background on what we do. Then a little bit more pertinent to the topic today, which is data disputes. So I just wanted to identify at a very broad level the kinds of areas where data disputes can arise that we've identified at least. So the main ones are basically in relation to data sharing or data processing. So we all know that personal data and data in general is becoming a very core part of the global economy. So through our discussions and through our experience, we've seen that where commercial parties are sharing data for various reasons, there can be breaches. And whilst that can, of course, lead to various claims from the data subjects themselves, it can also lead to disputes because those breaches will, of course, be a breach of contract, as certain security systems may not have been in place. And that is what led to the breach, for example. So I just gave a few examples with mentioning analytics. Obviously, this is where data is shared between companies, where one company may share it with another for the purpose of that company being able to analyze that data. Perhaps they are able to provide a more sophisticated service, or they obviously have experience. So that's where data can be shared. And another area is data scraping. And that is where companies sometimes will use publicly available information, which is available on websites, but they use it for commercial reasons. And that can be a breach of the website terms and conditions. So I've mentioned there as well the disputes, breach of contract and breach of website terms. So that's kind of a very general overview of the kinds of disputes that could arise in relation to data. In terms of the WIPO Center's role in this, as I mentioned earlier, in relation to business data disputes, we can of course assist parties in selecting neutrals, as we have a particular specialism in IP and technology, and therefore we have arbitrators and other neutrals with understanding of the key issues in data processing. Our rules themselves, the rules under which disputes are resolved, have specific provisions on confidentiality and trade secrets. And of course, where sensitive data is being exchanged, that's particularly important. And as I mentioned earlier, we obviously have, we benefit from international neutrality. I thought I would also just cover briefly an example case that we had, which involved, which at its core had the personal data. So this was an arbitration case in relation to a banking software dispute, and the contract involved the provision of a data processing software and services by a US company to an Asian financial institution. And that data processing, those data processing services included processing of account data of the customers of the financial institution. A dispute arose during the agreement about whether the financial institution had breached the exclusivity provisions in the contract by using a different data processing provider. The clause included an arbitration clause for WIPO expedited arbitration, and the WIPO Center assisted the parties in nominating an arbitrator candidates with experience in the IT and arbitration sector, and the parties ultimately agreed on the candidate they would like to use. This arbitration effectively the dispute was resolved through the WIPO expedited arbitration procedure, and the parties resolved the dispute whilst reducing the costs and the risks and complexity of the potentially multi-jurisdictional litigation by using the single expedited arbitration procedure. So the reason I just wanted to cover this was to just explain that whilst obviously when people discuss data disputes, they often think of the issues that arise where there's a data breach. In fact, there can be disputes where whilst there may not have been a data breach, there can be other disputes, but at the heart of that dispute is the sharing of data. And here it was the sharing of data of the financial institution's customers. And obviously it was the financial data, which can be very sensitive. So moving on from that, and related to that is our ADR services for fintech. So this is an extract from our website, and I've included a link on the slide in case anyone would like to read a little bit more. So again, with fintech disputes, we all know that technological developments in the area of fintech are on the rise. There's a lot of innovation. And there are a lot of different stakeholders involved. And of course, where there are a lot of stakeholders and where sensitive information such as financial information is being shared, there's obviously a potential for a dispute or breaches that can then lead to a dispute. So ADR is obviously particularly suited to such dispute resolution because here ADR allows parties to choose their neutral who has specific legal and technical expertise in the fintech sector. And it also provides a neutral forum and assists parties in resolving disputes without having to consider many different jurisdictions. There's a list here of the selected areas of dispute, which I won't go into, but obviously more information can be found on our website. Another area I just want to cover is life sciences. So obviously this is very topical at the moment, and here, what I'd like to flag is that in the life sciences sector, of course, clinical trial data is often is very important and will be shared, may be shared between companies where there is sharing of know-how or show-how. So again, although this may not be the first thing that comes to mind when you think of data disputes, ultimately, this is how personal data or any kind of data is actually extremely is at the heart of many different sectors, including the life sciences sector. And here, even if there's no breach of data subject rights, there can also be breach of IP because obviously there are rights attached to that clinical data. So on this slide, we just have an overview of the ADR services that we've recently launched for life sciences. Again, I won't go into them in detail. There's a link at the bottom of the slide, where you can access more information. But I just want to cover that the sort of key services that we provide, obviously in addition to standard arbitration and mediation, is a mediation service where parties are attempting to conclude a contract. This is before a dispute has arisen. This is actually where perhaps two parties are trying to reach an agreement, but are having difficulties doing so. We can assist them with appointing a mediator who can then assist in that contract negotiation. And secondly, we have where there are disputes in relation to long-term collaborations, we also offer mediation services and a dispute resolution board service, which can then be used in conjunction with arbitration. So yeah, thank you for your attention. I'll pass over to Ignacio now.
Thank you very much, Rita. Rita has covered the general areas of the WIPO Arbitration and Mediation Center's activities involving data, except for this last area, which I am going to cover, which is the area of digital copyright. As you can see from the slide, we have been working on a report. This report basically analyzes the results of a survey that the WIPO Arbitration and Mediation Center has been conducted with the help also of the Ministry of Culture of the Republic of Korea. This has been a very detailed survey with more than 1,000 replies involving participants from more than 120 countries. What we found out through this report is that disputes can arise in many different areas of digital copyright: software, musical works, advertising, literary works, photography, and databases. We have found that disputes are very common, increasingly common. More than 60% of the respondents to the survey have been involved in a dispute in the last 5 years. And we also found out through a series of interviews with some of the people who replied to the survey that the participants in the survey were not always entirely happy with how disputes were being resolved, and they suggested some improvements to the dispute resolution mechanisms that are currently being used. The survey also included an analysis of different legislations, and in this regard, as you can see in the next slide, we the authors of the survey, which included some professors at the University of Oxford, Dev Gangji, and other authors, they looked at different legislations. In particular, they looked at the US Digital Millennium and Copyright Act of 1998, at the notice and takedown procedures available under that legislation, and also more recently, they considered the European Directive on copyright and related rights in the digital single market, which includes several provisions which refer to alternative dispute resolution. In particular, the directive includes references to mediation at Article 13 in relation to the access and availability of audiovisual works on video-on-demand platforms, and to the need to assist parties facing difficulties concerning licensing of the rights through mediation. And that's something that we have been looking at, and I will show you in a minute how we are trying to facilitate the resolution of those disputes. The directive also at Article 21 includes reference to alternative dispute resolution in relation to transparency obligations and fair remuneration in contracts involving authors and performers. And here there is a possibility to have ADR to deal with disputes relating to contract adjustment, which of course can include also the accuracy of data provided to authors and right holders. And this may arise particularly when those works have been particularly successful. Finally, the directive also includes at Article 17.9 the possibility or the need for member states to ensure that out-of-court redress mechanisms are available for disputes involving the use of content by online content sharing service providers. And to reply to these to the provisions in the directive, as well as to try to respond to some of the cases, to some of the disputes that we have been dealing with at the center for the last few years, we have then developed some model mediation submission agreements. And in the next slide, you can see a model mediation submission agreement for, next slide, please, Rita, if you don't mind. So in this slide, you can see model mediation submission. Sorry, is the earlier one, just one up. I think there's a lag. Yeah, so this is the video on demand model submission agreement. And here you can see that it's a standard mediation clause, but in the second paragraph, you see that the subject matter of the mediation concerns the negotiation or determination of the terms of the license relating to some specific copyright works, and also determining whether the parties have already a license and this license needs to be adjusted. This clause has been developed also taking into account some work that we have been conducting in the last few years in the area of patent standards, what are described as FRAN disputes, fair, reasonable, and non-discriminatory licensing terms, which we have been handling particularly in the last few years. And in fact, Rita has been handling many of these cases in the last year. We have also seen some large disputes involving collective management organizations, copyright collective management organizations, and online content sharing service providers. And the subject matter of the dispute in those cases was precisely the determination of licensing terms. So this is the first model clause that we developed to respond a little bit to these legislative best practices arising from the DMCA and Article 13 of the Digital Copyright Directive in Europe. The second one, the second model submission agreement, relates to disputes regarding the transparency obligation and contract adjustment. And once again, what we have done is we have adapted the standard model mediation clause when it relates to the scope of the disputes. And here we have included the wording that you can see at paragraph 2, the accuracy of data in usage reports, including reproductions and time reproduced, downloads, digital sales, and geographical scope for the purposes of remuneration. And then we mentioned the appropriate level of remuneration. So this is just some guidance to the parties to try to determine the scope of the dispute and try to facilitate submission to mediation. These, again, we have taken from some disputes that we've been handling over the last few years. And these disputes, once again, involved copyright management organizations and their members very often, including sometimes television channels. So this is something that is available. And then just finally, in relation to Article 17.9, what we have done is, and you will remember that 17.9 establishes that member states shall ensure that out-of-court redress mechanisms should be available for the settlement of disputes relating to the use of protected content by online content sharing service providers. And you can see in the next slide that we have developed what is called the WIPO expert determination rules for user uploaded content, WIPO EDUC. What 17.9 provides is that in the first instance, OCSSPs need to have algorithms to deal with automatic filtering of content uploaded by users. And this algorithm will review this content. And if the content matches some copyright work, the content will be blocked. Otherwise, the content will remain available. If the content is blocked and the user contests that content is infringing, then the platform, once again, needs to have some human review process to consider that challenge by the user. And as a result of that, as a result of the human review phase, the platform will continue to block the content or will make it available. If the content remains blocked, then our procedure, our new WIPO expert determination procedure, will be available. And there, what we will do is we will appoint an expert. So this is an expert in copyright, to consider whether some of the limited copyright exceptions and limitations which are mentioned in Article 17.9 apply, and therefore the content should be made available or not. And finally, the decision of the expert determination procedure will always be subject to judicial review, and that is available, that is mentioned, of course, in 17.9 of the directive. So we have developed this process just to, based on the Article 17.9 of the Digital Copyright Directive, but also looking at other legislations which deal with this type of disputes. In substance, the procedure is based on the analysis of a limited number of exceptions and limitations, which you can see in the next slide. So in the next slide, you see that there is a definition of non-infringing use. So this is when the user, the platform user, can rely on a limited number of exceptions and limitations when he uploaded the content in the online content service sharing provider. So the exceptions are limited. So this is quotation or criticism or review, or has been made for the purpose of caricature, parody, or pastiche. The idea is that the user has to select only one of these exceptions and limitations, and this is just to make it to make the procedure as fast and efficient as possible. Of course, the European Union member states have had to implement the directive. We have been following the implementation by the different member states. The implementation has taken place in very different ways by different member states. And what we have done is to reflect all the different implementations of the directive. And we have developed these WIPO expert determination rules to make it as efficient as possible. And the idea is that the procedure can be resolved within a very short period of approximately 7 working days, or maybe slightly more, depending on the complexity of the case. So we are working with some of the member states who will make probably available the possibility to go to WIPO expert determination, in addition to whatever national procedures are available. And we are also going to be running a pilot program with a company that it's a US startup that provides copyright attribution engine services to copyright holders, and will be offering these WIPO EDUC rules to resolve disputes involving right holders and platforms. So I think we will stop there. Here you have a lot of information and links which will lead you to the center's website, and of course I will be very happy to answer any questions. Thank you very much.
Thank you very much to you, Margarita and Ignacio, for this very rich and fruitful presentation, which confirms that, as we know, data is everywhere, and data disputes are also affecting basically every industry, from the life science industry to the banking industry, based on the example that you shared with us, Margarita, and also to what you just said, Ignacio, in terms of copyright dispute and digital disputes, and also for pointing out the very interesting regulations and new dispute resolution systems that you've been developing at the center. And now we are basically, and we'll keep the question for the end of the session, and suggest that we shall now turn to another type of disputes. So we've been discussing so far about commercial disputes essentially, and commercial arbitration, about data essentially in a B2B context, business to business context. Now we're gonna turn to a different topic, which will be presented by our next speaker, Alejandro Garcia. And we're now turning away from commercial disputes and commercial arbitration to address investment law and investing arbitration, and to talk about data disputes in that context. Alejandro, you have the floor.
Thank you, Jacques. And thank you to the host, the Digital Law Center and the WIPO Arbitration and Mediation Center, for having invited me to deliver this presentation. I will discuss 3 subjects today. So the first one would be an introduction to investment treaty protections, investment treaty arbitration. The second subject I will discuss today relates to whether investment, where data can be an investment for the purpose of protection of these treaties. And the third subject I will discuss today relates to a case. There's an investment treaty arbitration. The only one known case involving data as an investment is a case against Canada and the Nafta. Okay, so the first topic I will discuss. I would want to share a secret with you and the audience, I suppose. It's always a good thing, but probably would disappoint you. But I'm saying about sharing a secret is because sometimes the press talks about investment treaty arbitration, saying there's a secret court deciding disputes involving states. And I will be talking about those secret courts today. Now, the disappointment is because there's nothing secret about them. This is a system that has existed for a long time. Perhaps it's not necessarily as mainstream as some would want, but it's a well-known system, is developed, and there are many decisions. And so the press sometimes says this is secret as a system. They're not accurate, but they want to criticize the system. I'm not going to discuss whether the system is good or bad. It is a system that has worked and has helped many countries to show that there's a rule of law in the countries that have this system of treaty protection, and in many respects has been, as I said, helpful for countries. For example, Mexico, by concluding NAFTA, helped a significant growth in the country as a result of the inflow of foreign investment, particularly from Canada and the United States. So it has been, in many respects, a successful system. Now, there is a network nowadays of around 3,000 of these treaties. Some are bilateral investment treaties, the BITs. Some are multilateral, like NAFTA, which is Mexico, Canada, and the United States. And other rather famous, I would say, multilateral treaty relating to investment is the Energy Charter Treaty. So these are called as MITs, and some of these treaties also disputes come from free trade agreements that have investment treaty protection chapters. So that's the different type of agreements that have these protections. What do they do, these treaties? well, they protect, in essence, assets of investors. I mean, sometimes the use of the word investment can be a bit confusing, and I will touch upon that in a few moments, but ultimately they protect rights, interests, and assets of investors. What are the protections about? Why this is interest, or why the cases, many cases? Well, these treaties provide very significant protections to qualifying investors. For example, they prohibit the host state, that's it, the country where an investment has been made, to impose arbitrary measures on an investment. Also obliges the state to act in a proportional way, in a proportional way, proportionality, and also it prohibits imposing what is called illegal expropriation, that is expropriation on unjustified grounds and without the payment of compensation. Now, and these are very significant protections that sometimes don't exist under domestic law, or if they exist under domestic law, you're in the hands of domestic courts to decide these protections. And then it comes one very important advantage of these treaties, that is, it affords foreign investors to have access to international arbitration. That means it's a neutral forum for the resolution of disputes against host states. So this means that these very significant rights that are afforded to foreign investors can be adjudicated, as it were, by a foreign neutral, but an international tribunal. So they don't need to go to a national court, they can choose the arbitrator. So that they're outside the legal system of the host state, ensuring neutrality. So that's the first part as an introduction. Now, it arises the question, can data be an investment? And this is a strange question in a way, but it's just different things. We're talking about different things. But I will explain why we're talking about investments. I think one of the puzzling aspects of investment treaty protection and investment treaty arbitration is the use of the word investment. Previous treaties and some draft conventions, and in fact, the word friendship and navigation treaties, in general spoke about property of aliens. And that was a better term, property of aliens, or foreign property. Now, in 1959, this is a treaty, the first known bilateral investment treaty was concluded between Pakistan and Germany. And that treaty moved from the use of the term property to the term investment. Now, apparently everyone after that liked the use of the word investment and did copy and paste. Now, problem is that investment is not a legal concept as such. It's more a financial concept, a concept of economics. So there is a mismatch. And this creates sometimes issues saying, well, look, can data as such be an investment? So that can give rise to questions, because it doesn't necessarily fit the mold. What's an investment? It's a business activity in a way. So and the answer to this so perhaps strange question, is data an investment, should be found in the wording of the treaties. So you need to say, first you need to find the qualifying nationality. For example, say you have a Swiss investor investing in Pakistan, then you say, okay, that treaty applies on the basis of nationality. And then, for example, if there's a data dispute, you need to have a look to consider the wording of the treaty in question. So, and allow me to then read briefly article, following with the example, to read briefly Article 1 of the Pakistan-Switzerland Bilateral Investment Treaty of 1995, which defines this: the term investments shall include every kind of assets, and particularly, letter D, copyrights, industrial property, rights such as patents, utility models, industrial designs or models, trade or service marks, trade names, indications of origin, know-how, and goodwill. So that is from the wording of this treaty, copyright is protected, also trade secrets. Those are the forms that normally take the protection of data, so databases and what have you. So under this treaty, yes, in principle, we're fine. Also, we have NAFTA. That is a different definition of what investment means. And NAFTA is relevant because the case we'll discuss in a few moments is under this treaty is NAFTA. So investment is defined in Article 1139 of NAFTA of 1994, and the definition that is relevant to our inquiry is investment means G, real estate or other property, tangible or intangible, acquired in the expectation or use for the purpose of economic benefit or other business purposes. So that's here, it's just not an express reference to IP, to intellectual property, copyright, what have you, or know-how, but it's just a type of intangible property. So also that is protected in principle, and this is the case we're going to be discussing in a few moments. Now, to come back to the complexity of whether data is protected under these treaties, let's have a look at a modern, much more modern, if you can say modern, but a more recent, perhaps, BAT. Is the model BAT, it's not an existing BAT, but countries have model BATs when they negotiate with other countries. So the Dutch model BAT of 2019 has a definition that says definitions for the purposes of this agreement. Investment means every kind of asset that has the characteristics of an investment, which includes a certain duration, the commitment of capital or other resources, the expectation of gain or profit, and the assumption of risk. Forms that an investment may take include rights in the field of intellectual property, technical processes, goodwill, and know-how. Now, so that's a bit of a perhaps an interesting definition, because you have certain requirements. You say, well, can, say, a database have certain duration, commitment of capital, the assumption of risk? And this is the disconnect between an asset and data as such. Now, so the answer is that whether data is an investment, well, the answer is a typical answer that a lawyer would tell you is it depends. It depends on the wording of the treaty. I wouldn't think that necessarily under the model BAT, the Dutch model BAT is not, but of course it's easier to say that data is an investment under the two first definitions. Now, data, and this an interesting question is, of course, the treaties that protect copyrights and trade secrets directly, there's no question as to data, if, for example, we have a database or trade secrets is protected. Now, the question that's perhaps more interesting and perhaps we can discuss at the end of the session is whether raw data can amount to an investment. Is raw data an asset? Perhaps it's a bit of a philosophical question, and we can discuss that at the end of the session, but that might be an area to explore. But certainly under the treaties that have had definitions, the two first treaties you have, I think is clear that we're talking about protected investments in principle. And that leads to the third point I wanted to discuss is the Nafta case, Einarsson. It's called Einarsson v. Canada. I think Einarsson is an surname from Iceland. I'm told this is the right pronunciation, Einarsson, but it's three. They're not Icelandic investors, the American investors. So US investors that own a company in Canada. So briefly, this case is the only known case involving data within the field of investment treaty arbitration. And it's a very interesting case for a number of reasons. So the notice of intent was sent to Canada by the US investors on behalf of themselves, the 3 US nationals and a local company established in Canada on the 10th of October 2018. Then the request for arbitration was filed on the 18th of April 2019 under the ancestral rules, which is one set of rules that is often used for commercial arbitration too. And as I say, it's 3 US nationals and on behalf of themselves and on behalf of a Canadian company called Geophysical Service Incorporated, GSI. This is under Chapter 11 NAFTA. A bit of background is GSI, the claimants, we only have the version of the that it has been put forward by the claimants. So that's an important caveat. We haven't heard from Canada yet because the papers haven't been filed as far as we know. So we have only the version of the story. And thank you, Jack, for sharing a link to the papers in that case. So we only have the version put forward by the claimants. Okay, so but it will be the background will be provided is based upon that. So GSI and its predecessors is a company that for 50 years created marine seismic data for the purposes of oil and gas exploration under the seabed in Canada. So this is they have amassed, they say, a vast, huge amount of data. The claimants say that GSI, the Canadian company, and by extension the US owners of the company from the viewpoint of the treaty, had copyrights over the data. And I think what they say, just because they have compiled the data, is how they have manipulated the data and organized it. That is under Canadian law. They also claim that they have trade secret protection in respect of the data. Now, what was the problem? The problem was that because of certain regulatory reasons, the claimants needed to share that data with the Canadian government. Okay, highly valuable data. What happened is that the Canadian government, after some time, started to share that data with third parties without authorization from the claimants. And the licensees that the claimants had for this seismic information that is very valuable for oil and gas exploration, then stopped paying licenses to the claimants because they said, well, I can get this for free from the government instead of paying millions of US dollars for the data. So, and as a result of that, of course, the business model of the company went south, as it were. So massive problems, no one wanted to pay for that. And basically the company went bust, as far as we know. I'm telling the version of put forward by the claimants. Now, the claim is massive. The claimants are claiming damages in the region of 2.5 billion US dollars because they say is the value of the data. They say like compiling the data cost them in excess of 700 million US dollars. So talking about massive amounts of money. One thing is interesting is also the Andersons and GSI litigated before the Canadian court, but they lost, and the Canadian court concluding, according to what the claimants say, that although they had copyright protection over that data, that was overruled by the regulations applicable in Canada. And so the claimants are saying, well, this is a confiscation of our intellectual property in relation to the data and our trade secrets that have been violated. And so that's why they have put forward this case, as is the only one known in relation to data. And we will see what happens. Although it has been commenced for some time, I think it's moving slowly. I think there was a challenge put forward before the Canadian courts because the case, maybe the tribunal is not constituted. But it would be interesting to see what happens, particularly to see what Canada argues in response. I'm sure they would attack whether this is an investment, etc., jurisdictional grounds. But Again, but this is in a way a groundbreaking case, and there are not many more broadly IP arbitrations, investment treaty arbitrations relating to IP. This is one of a few of them. So one is a patents case, Eli Lilly v. Canada, and they have Bridgestone v. Panama as cases, but the first one relates to patents, the second to trademarks. So this is the first one, as I said, in relation to data. So stay tuned, and we'll see what happens, and what I have said perhaps will be tested in relation to what's an investment or not. But and I said that's an interesting decision, and that we will keep an eye on it. Thank you.
Thank you so much, Alejandro. We'll certainly stay tuned. This is really a fascinating discussion, and to me, it's also interesting to see how data is somehow testing the limits of investment law and investment arbitration, and trying to see to what extent data, as you mentioned, and perhaps we can get back to that in the discussion, raw data can qualify as investments, and also this shift in the economy today and certainly tomorrow, in which intangible assets obviously have a key value for companies and also for governments. So it will be of highest interest to see what will unfold in that ongoing dispute. And as you mentioned, there are other cases dealing with IP as such, but more classical IP categories, patents and trademarks. And you also referred to that Bridgestone versus Panama case, in which it's also interesting to see that the asset at issue is at least partly also a licensing transaction. So it's not the IP asset as such, but the license asset, with the question whether that can qualify as an investment as such. So a lot of fascinating questions on which we will certainly be in a position to come in the discussion. There is a discussion. This is also an opportunity for me to invite all of you to ask the question that you may have along the way in the chat, as that was done by Christian Laux with a question on the WIPO Edu Dispute Resolution System, to which we will come at the end of the session. But for now, I wanted to very briefly share a few thoughts and comments, obviously from an outside perspective, from the other side of the world, so to say, on this Australian regulation, given that Mary Walker unfortunately couldn't join us today. So I will now share my screen and just say, and I hope you can see that, and just say a few words about that, and also come back briefly to the ongoing development taking place in Europe, and specifically in the European Union, from a corporate perspective. So the regulation which has been adopted in Australia is the one that you have on the screen. So the News Media and Digital Platforms Mandatory Bargaining Code, which was adopted after debates and struggles between the global platforms, and specifically Facebook, as you can see on the screen, and the Australian government. And the core of the disputes, there are various aspects to that quite sophisticated and extensive regulation, but the core of the dispute is about sharing of profits that are generated by the internet platforms, which basically reuse the news, as you can see in the title of that recent headline of the New York Times. So sharing of the profits with the Australian news platform, which is really at the core of that new regulation. Now, what is also interesting about this regulation, and of course without claiming to have an inside view on this Australian regulation, but by going through it, is that you have certain provisions contained in that new regulation by which there is an obligation to share data about user interactions. So this is something which is emerging in the course of which we see that platforms, as we know, detain a lot of very valuable data about what their users do with the content which is made available on the platform. And you see here that there's an obligation of the platform to share data about the interactions of the users of those platforms with the contents, because obviously if you can get access to that data, that will give you a lot of insight as to what type of content is relevant, what type of content is used, and how it is used by your user. Quite importantly, as you will see at the bottom of the screen, this is not a mandatory obligation in the sense that the platforms will have an obligation to share only if they have shared with one platform. So if they don't share at all and they decide not to share, so it's kind of a soft obligation which results from that provision. Now, when we talk about sharing of data relating to users, obviously we have to look at what this may imply and what kind of impact it may have on the protection of personal data. So there have been statements and positions expressed in the course of the adoption of that regulation in order to make sure that data protection principles under Australian law are complied with. This has led to a position taken by this Office of the Australian Information Commissioner that you can find online, of course, making sure and inviting the entities in charge of the implementation of that regulation to comply with personal data protection, which has materialized in the requirements to make sure that the data is anonymized, pseudonymized, or aggregated in a way to minimize identification, which triggers the more general and also quite important issue as to whether personal data disputes can be submitted to arbitration, whether that is something which is feasible. If you look at the market, you have, among others, this platform, a UK-based platform, which does offer arbitration services, ADR services for data breach disputes. Of course, as we could hear, and it is well known and as reflected earlier by Margarita Kato, she indicated that data disputes are not only about data breach, that's for sure, but you see that this service provider has somehow focused its activities on that type of disputes, with the question, as I just mentioned, about whether these personal data disputes can be submitted to private dispute resolution mechanisms and specifically to arbitration. Now, interestingly, in that Australian regulation, you have a multi-tier dispute resolution system under which, as a first step, there's an obligation of the platform to participate in a mediation, and that relates to the issue of the sharing of revenues, so the issue of remuneration, which can then, as a second step, materialize in arbitration about the remuneration. Interestingly, this is a so-called final offer arbitration, so baseball arbitration, as we would call it, by which the arbitration panel is invited to decide which of the two offers submitted respectively by each of the parties can be adopted, knowing that the arbitral tribunal still keeps the freedom to reject both of them if they are not, as you can read, in the public interest. So kind of a simplified arbitration system, but which is still interesting to observe. It will be also interesting to see how this may be used in practice. Now, quick look, and coming back to what was discussed earlier by Ignacio de Castro, look at the EU copyright directive, in which you have this obligation of transparency, you have the full wording of the provision on the screen, which is actually Article 19 and not 17 as inadequately reflected at the bottom of the screen. Apologies for that. So obligation for transparency, which obliges the platform or the contracting partners of the authors to give and share info about the way how the work is used and the revenues which are generated, and also about the remuneration which is due to the authors. What is interesting in the system is that the obligation of transparency does not apply only to the immediate contracting party of the author, but also apply to the next entity in the chain of licenses. So that means the author, based on Article 17, can also obtain directly, if this is set up in that way by the implementing regulation in the member state, they can obtain information directly from the sub-licensees of condition. So that's interesting to observe, also because that may mean that the disputes might be multi-party disputes. If we look at the obligation for transparency, what is it in a nutshell? And fundamentally, it's an obligation to share data. So that confirms that from a corporate perspective, as we could hear and as we could also see in the WIPO rules, which have been presented earlier, this is something which will certainly grow in the future. Also because, as already mentioned, there is a possibility to submit to so-called voluntary ADR system in order for the author to enforce their right of information and the obligation of transparency of their contracting partners. Now, what does that mean? Does that mean that the ADR system is supposed to be voluntary, or is it supposed to be mandatory for the licensees and sub-licensee? If you look at another provision of the directive, you would see that it's not possible for the parties to circumvent, to waive this right to have an ADR system. So that would mean that the parties will have to submit to that if the authors wish the dispute to be submitted to ADR. There are still a few questions which remain open. So are we talking here about mediation, or can we also conceive that arbitration is also part of the ADR system contemplated under the directive? Are we also thinking about multi-party proceedings? And this is what I just reflected upon a few seconds ago when saying that the obligation for transparency can be enforced not only against the licensees, but also potentially against the sub-licensees, who shall bear the cost. Obviously, the entire system of this obligation for transparency is to help authors. That means that authors shall get access to the ADR system without cost or at a limited cost. Anyway, here again, we'll have to observe what may come in the future, given that some member states still do have to implement the obligations of the directive in that respect. So, and that's perhaps also an introduction to the discussion that we shall now have. What can we see in terms of potential future developments for arbitration and ADR for data-related disputes? I think this is certainly an important tool in the toolbox for solving data disputes for the general reasons that we know, and that our value for ADR in terms of confidentiality, but also for global dispute resolution mechanism, and also for data disputes. So it should certainly be part of that toolbox, and perhaps from a Swiss perspective of the Swiss knife, which can hopefully help solve this type of dispute. So this is basically what I wanted to share, and I now suggest that we shall take the questions that have been put on the chat, starting by the question, and I would invite everyone to look at what's on the chat, starting by the one which was put and submitted by Christian Laux, that I'm going to read aloud, and perhaps I can turn to Ignacio de Castro for that, but first I can read it. So the question is, with respect to the slide discussion of the presentation made by Margarita and Ignacio discussing the workflow of the WIPO EDUUC dispute system, the question is, how does the algorithm distinguish whether the user uploading the content has a license from the right holder? Ignacio, would you like to take that question?
Thank you, Jacques, and thank you for the question. So yes, this was something that we considered quite carefully, and I should have mentioned that we developed the WIPO EDUC rules with the help of a group of international experts, which included Jacques de Werra. So thank you, Jacques, for your participation in that group. And as part of that discussion, in fact, I do remember that Jacques mentioned the issue of licensing in one of the calls that we had on this. We thought at the beginning of the drafting of these rules that the issue of licensing could be added to the questions of copyright exceptions and limitations. And then we kind of realized that it was a big job for any expert that we would have to appoint to have to consider the issue of licensing as part of the WIPO EDUC rules. So we decided to limit the WIPO EDUC rules just to the exceptions and limitations that are mentioned in Article 17 of the directive. And we did not include licensing in the scope of the EDUC rules. Of course, the issue of licensing, nevertheless, could be a potential issue, which would have to be considered, perhaps in the earlier stages of the process, in the first instance, and in the algorithmic phase conducted by the platform, where they will be doing the automatic filtering. And this is because, for instance, when we look at the partner that we're working with, what they do is they deal with declarations by right holders of rights. And as part of those declarations, they may have also the declaration of certain licenses. And of course, they declare those licenses because they expect to get some monetization of that content through those licenses. So if nevertheless the algorithmic phase or even the human review phase were not aware of the issue of licensing to a user, that could be raised by the user, particularly in the human review phase, or in the worst case scenario, in the judicial review phase. So that's how it could be handled. But you, as the question mentions, the question of licensing is not part of the scope of the WIPO EDUC rules, because that could have entailed a much more detailed analysis of different licenses, different contracts, and that goes beyond the work that the expert has to do within a very short time frame. And particularly if, for instance, there would be multiple licenses, with the possibility, as it happens very often in copyright disputes, that there could be multiple declarations or overlapping contracts. So that we decided to exclude from the EDUC rules. Thank you.
Thank you very much, Ignacio. I see there are other questions on the chat, starting by the one submitted by Sabrina Schneider, who asked, and if I quote, "How do you see the future of resolving B2B data disputes in arbitration, given that the new EU standard contract clauses for data transfer," I assume this is what you meant, "require state court litigation?" And then the question continues by saying, "Of course, the company subject to EU, UK, GDPR, Swiss law could still have an arbitration agreement in the main data transfer processing agreement, but that company runs the risk of having to resolve a dispute in multiple fora." Any thoughts on that from our panelists? Alejandro, any?
Yeah, that's an interesting question, isn't it? About sometimes you have questions on arbitrability. You know, it's a topic I have discussed extensively. Can, you know, if you have a compulsory jurisdiction, can you arbitrate, and so on? So that's, I suppose it is evolving, and we will, there would be sometimes certain disputes that you can't submit to arbitration, or you don't have an arbitration agreement, isn't it? So that's the issue when you have non-contractual disputes, you don't have necessarily an agreement in place, and you would need to go to court. And perhaps the question is, perhaps a comment to WIPO saying, well, look, most of the disputes that relate to data still they arise from a pre-existing relationship. But I don't know if the scope for those disputes that don't have a pre-existing relationship, where those could be submitted, or there's a scope for the parties to agree to submit to those disputes to arbitration.
Thank you very much, Alejandro. If I may quickly react on that, I think that's so far, that's my perception, perhaps personal data regulations and policies have viewed litigation and traditional dispute resolution mechanism as the way to solve personal data disputes, but I don't necessarily think this is really the optimal solution, also because of the risk that it may geographically fragment dispute resolution mechanism. This is the point that you make in the question, Sabrina Schneider, and I think for that reason would be interesting to see how we could create an ADR system and perhaps an arbitration system which would make it possible to solve this dispute in one single forum. And if you think, at least from a Swiss law perspective, as a matter of principle, personal data is one category of right of personalities. And if you look at other rights of personalities, and specifically, for instance, image rights, we have experienced, I think, a tendency to consider that image rights can be the object of arbitration proceedings and ADR proceedings because they also have an economic value and they are put to use by third parties. So I'm not, of course, claiming that personal data protection should be commercialized and should be submitted to unlimited dispute resolution mechanism, including by arbitration. But I think would be interesting in the interest of the parties at issue, and that's as reflected in the question which is submitted to us, to perhaps think in a creative manner about the way how to manage these multi-territorial disputes in one single forum and by way of one single proceedings. So yeah. I think it would be interesting to observe on that front too what may happen in the future.
Yeah, and that's the benefit, of course, of international arbitration, because you can have, in relation to IP disputes, sort of IP disputes are territorial. I mean, the rights are territorial, but disputes tend to be international in nature. So international arbitration has a role to play there. So that's something, again, but you need an agreement sort of to have party agreement, or sometimes states can do that. They can sometimes say, well, this type of dispute would be subject to arbitration, a sort of a compulsory type of arbitration, which, as I understand it, for example, has been the case in Spain, for example, in relation to low value disputes with airlines, so customer airline disputes. So there's a mechanism. So in Spain, historically, there's some reluctance to use arbitration. I don't know why. I'm not from Spain. Ignacio might maybe able to comment on that. But now there's a shift, because they say, like, sometimes there's so many disputes, courts can't cope with that. So I think there is room for disputes, perhaps that very significant for someone. It's just personal data, but perhaps courts don't have the capacity to react. Arbitration or ADR more broadly has a role to play in those, particularly have an international element.
Absolutely. I think Ignacio wanted to react.
Yes, I just wanted to say that, as you probably saw from the slide that Rita mentioned at the beginning, where we were showing the share of disputes between contractual and non-contractual disputes, we are seeing a much bigger share non-contractual disputes. And these disputes relate precisely to what the question relates to, which is the submission of a dispute to arbitration or mediation. And there, what they are trying to do is just to define the scope of the dispute by reference to sometimes to several different applicable laws. And this we are seeing, historically we saw it first in patents. Now we are seeing it in the area of digital copyright, and I mentioned some disputes involving platforms and CMOs, and of course the same thing could happen with data disputes, where you could try to submit to an arbitration tribunal a particular dispute, including different applicable laws. And what has been interesting in some of the cases that we've dealt with is that the dispute started before the national authorities, for instance, the copyright tribunals in the UK, and they moved the case to arbitration because they wanted something which was much more global. And that's certainly something that we would be very happy to help parties to facilitate the submission of those disputes to either mediation or arbitration.
Thanks very much, Ignacio. I see there's another question on the chat by Felipe Rocha, and I'm reading the question before turning to our panelists. Could an arbitral tribunal apply to dispute resolution between a person and a company other regime beside the GDPR? If the arbitral tribunal does that, are there any problems regarding to this in terms of the enforceability, recognition of the arbitral award? Any thoughts on that from our panelists, Margarita, Ignacio, Alejandro?
I think I'll just emphasize that again, that at least what we discussed was more business-to-business disputes and not where an individual's personal data rights have been breached. And that's what would be covered under the GDPR. So I'm not sure about whether an arbitral tribunal, whether they would apply dispute resolution under GDPR, because obviously that would be a breach of their personal data rights. And that would not necessarily be arbitratable. So I think that's just my only comment, unless anyone else had any comments.
So I think, but this is an interesting question. I mean, why would the tribunal apply something different if it's something mandatory? And it can happen. And sometimes the parties, for example, I mean, a tribunal would be reluctant to depart from that. But suppose that the parties agree on something, say, just apply something different, or they might waive their rights, etc. So it's an interesting scenario. I think tribunals would be careful not to, as an arbitrator, you're very careful to ensure that the award is enforceable. And certainly if you are violating the sort of mandatory law, the loi de police, a public order of what we call of the place of enforcement, that is an issue. So I would think it's something that should be avoided. But it depends on whether you would need enforcement. I mean, sometimes you can have mechanisms where you don't need to enforce an award. For example, you can have a dispute, perhaps not the case, GDPR in relation to a license, but sometimes you don't need to enforce. It might be a declaration you want, it might be something that is self-contained, as it were. So, but certainly you, an arbitrator would be would be slow to allow something that could damage the enforceability and award, because that's one of the duties of the arbitrator, and they will be keep an eye on mandatory law.
Thank you. There was also another question about publications or paper on data dispute resolution. I think in addition to what I have written in the past, I think one thing which is important is to realize that when we talk about data dispute, it's not necessarily a revolutionary field, in the sense that if you look at non-personal data or industrial data, These type of disputes may qualify as trade secret disputes. So this is, of course, not new to talk about trade secret disputes. So that's probably something which needs some reconsideration and updates also in light of upcoming developments with respect, for instance, of the emerging development of data trusts, so entities which are supposed to act as intermediaries between owners of data and users of data, in which you may think that there are interesting developments to be made in terms of dispute resolution mechanism, perhaps arbitration for this type of data dispute. But as a matter of principle, trade secret disputes and trade secret arbitration is not new, of course, on the international dispute resolution scene. Now I see there are, as far as I can tell, no more questions on the chat. Just a reaction by Sabrina Schneider, also expressing a positive view on the development of arbitration for this. So it remains to be seen on that front too, what may result out of that. I just briefly, given that we have just a few minutes left, wanted to get back to the question that you have mentioned, Alejandro, in terms of possibility and talking about investment arbitration, possibility to consider raw data as an investment. I was looking very briefly at the bilateral agreement to which you referred between Switzerland and Pakistan. And interestingly, as far as I can tell, in the list of IP assets, there is no reference to trade secrets. And there's just one reference to industrial property. So the question was, could we consider that protection of raw data can be admitted as a category of trade secrets, or can we consider that we can protect? Of course, you will answer, and you will of course be right, that it depends, as you already indicated, in the sense that it will depend, of course, on the wording of the relevant treaty. But I was wondering whether on the question of protection of raw data as investment, we may find a source of protection in the protection of trade secrets. That would be my question.
Thank you, Jacques. Yeah, I agree. I think sort of we'll say the Pakistan Switzerland BAT says copyrights, industrial property rights, such as so it is only examples, patents. So it doesn't include trade secrets, but if trade secrets is an industrial property right under the law, and is important that the law or the place where you have that, say, if, for example, it's a Swiss investor suing Pakistan, you would need to assess whether trade secrets are protected as a type of industrial property right, as you say, or I mean, in English, of course, you say intellectual property, which just encapsulates everything, but that would be the question. And to me, the answer is yes, it is a right. This is only an enumeration. By way of example, it doesn't exclude it because it's really broad. And if you go sort of first party said every kind of assets, and particularly, so it's really broad. Now the question is, I mean, I think to me, if it's trade secrets, if it's secret data, that to me would be protected. Now the question is raw data. Besides that, is say, well, you have a compilation of raw data that might not be necessarily a trade secret, but it's not even the compilation, is what you do with that, you know, what is raw data is an interesting question, isn't it? Is you put something together, is information about something. So I suppose it depends on what is the configuration, what is the shape that takes, and you know, perhaps raw data is too abstract, maybe a question. You would need to understand the case, sort of what are we talking about? Because ultimately, if there's something of value, you would probably need to compile something. You would need to have some form to use the data, sort of information without being compiled. It just, you know, perhaps on a computer streams of zeros and ones, you know. So said, I mean, it would depend on the case, but I think particularly in the shape it takes, how the data has been compiled. If you think about, say, say Facebook, they compile data, user data, isn't it? And that has a significant value. Is that raw data? I don't know. I think it is not necessarily raw data. It is how you, is the compilation, the filtering of that information, and what you do with that.
And this is, I would agree with what you just said, Alejandro. And this is in a way why we were also including reference to life sciences disputes, because as Rita was saying, of course, there you have transfers of clinical data. I wouldn't be able to say whether that's raw data or something else, but I think it's all that combination of elements really which can be the know-how, part of know-how which is being transferred, and that's why we thought that it would be useful to mention also those type of life sciences disputes as part of this webinar, because we see that there are considerable transfers of data, which of course really under the WIPO arbitration rules are also covered by the protection of trade secrets in Article 54 of the rules. So that's why it's good that we are connecting this at the end of this webinar. Thank you.
Thank you very much for this. Any final thoughts from our speakers, Margarita, Ignacio, or Alejandro?
No, just it has been a great pleasure. That's my final thought. Sharing.
Same here.
With you.
Thank you again, Jacques, for the invitation.
Thank you. Thank you very much to all of you. Thanks also very much to Sébastien Aubert from the team at the Digital Law Center for helping out and setting up this Zoom session. So as Alejandro mentioned, certainly a lot to keep on our radar for future development, interesting perspectives, and looking forward to a next opportunity to discuss about this very challenging and promising issue. So thanks very much to all of you, and see you online at an upcoming event. Thank you.
Thank you, Jack.
Thank you.
Very much.
Bye-bye. Bye-bye.
Goodbye now.
Thanks.